So today I'm going to present about private international law, and the section that I'm discussing about is Alibi Pendens. And my name is Perdata Internasional, and PM 1851067, and I'm a college student from Perdata Internasional Batam.
Conflicts of law or private international law or international private law branch of international law and interstate law that regulate a lawsuit involving a foreign element where a difference in result will occur depending on which laws are applied as the lex causa. The aspect of private international law, the first one is the jurisdiction of a Rome, the competing states laws, and the enforcement of foreign judgment. Its three different names are generally interchangeable, although none of them is wholly accurate or properly descriptive. Within a local federal system, where interstate legal conflicts require resolution, such as in the United States, the term conflict law is preferred simply because such cases are not an international issue. Hence, the term conflict law is a more general term for a legal process for resolving similar disputes, regardless if the relevant legal system are international or interstate. So this term is also criticized as being misleading in that the object is the resolution of conflict between competing systems rather than conflict itself. The stage in a conflict case, the court must first decide whether it has jurisdiction, and if so, whether it is the appropriate venue given the problem of forum shopping. The next step is the characterization of the cause of action into its component legal categories, which may sometimes involve an accidental question. Also, note the distinction between procedural and substantive laws. Each legal category has one or more choice of law rules to determine which of the competing laws should be applied to each issue. A key element in this may be the rules on will void. Once it has been decided which law to apply, those laws must be proved before the forum court and applied to reach a judgment. The successful party must then enforce the judgment, which will first involve the task of securing cross-border recognition of the judgment. In those states with an underdeveloped set of conflict rules, decisions on jurisdiction tend to be made on an ad hoc basis, with such choice of law rules as have been developed embedded into its subject area of private law and tending to favor the application of the lex lori or local law. Instead, with a more mature system, the set of conflict rules stands apart from the local private civil law and adopts a more international point of view both in its terminology and concept. For example, in the European Union, all major jurisdictional matters are regulated under the process regime. The rule of Alibi Pendens from Brussels apply in new member states, and interpretation is controlled by the European Court of Justice rather than by a local court. That and other elements of the conflict rules are processed supranationally and implemented by treaty or convention because these rules are directly connected by aspects of sovereignty and the extraterritorial application of laws in the court of the signatory state. They take on flavor of public rather than private law because each state is compromising the usual expectation of their own citizens that they will have access to their local courts and that local laws will apply in those local courts. Such aspects of public policy have direct constitutional significance, whether applied in a European context or in a federated nation such as the United States. Canada, and Australia, where the courts have to contend not only with jurisdiction and law conflicts between the constituent states or territories, but also as between state and federal courts, and as between constituent states and relevant laws from other states outside the federation. Choice of law rules. Court faced with a choice of law issue have a two-stage process. The court will apply the law of the forum or lex fori to all procedural matters, including self-evidently the choice of law rules. And the second, it counts the structure that connect or link the legal issue to the laws of potentially relevant states and applies the law that have the greatest connection, the law of nationality, lex patri or domicile, will define legal status and capacity. The law of the state in which land is situated will be applied to determine all questions of title. The law of the place where a transaction physically takes place or of the occurrence that give rise to the litigation will often be the controlling law selected when the matter is substantive, but the proper law has become a more common choice. The status of foreign law when the court is to apply a foreign law, it must be proved by foreign law experts. It cannot merely be pleaded as the court has no expertise in the laws of foreign countries nor in how they might be applied in a foreign court. Such foreign law may be considered no more than evidence rather than law because of the issue of sovereignty. And to apply one national legal system as against another may never be an entirely satisfactory approach. The parties' interests may always be better protected by applying a law conceived with international realities in mind. The Hague Conference on Private International is a treaty organization that oversees conventions designed to develop a uniform system. In this section, we have characterization. Characterization is the procedure to resolve a lawsuit involving a foreign law element. Once the foreign court has decided that it does have jurisdiction to hear the case, it then must characterize or classify the causes of action. The process, the court is required to analyze the pleadings prepared by the parties and to assign each component element to the most appropriate jurisdictional concept or category. The rules of any given system of law are arranged under different categories, addressing procedure, status, contract, tort, default, and nullity. For each category, there is one or more choice of law rules. The second, an incidental question, is a legal issue that arises in connection with the major cause of action in a lawsuit. The forum court will have already decided that it has jurisdiction to hear the case, resolving any issue relating to forum shopping, and will be working through the next two stages of the conflict process, namely characterization and choice of law. For an incidental question to arise, the forum court must have applied its characterization rules to determine that the main cause of action is governed by a foreign law. As a precondition to the main cause of action, there is a subsidiary question which has its own choice of law rule pointing to a different lex causa. There will be a different result depending on which foreign law is applied. The procedure for conflict cases. The court must first decide whether it has the jurisdiction to hear the case, which will involve addressing the question of whether the plaintiff is attempting to manipulate the judicial system by forum shopping. Characterization. The court must analyze the case as pleaded and allocate each component to its appropriate legal classification. Each of will have one or more choice of law. Rules attached to it. The court will then apply the choice of rules in a limited number of cases, usually involving family law issues and incidental questions can arise which will complete this process. And the next one is renvoi. Renvoi from the French meaning send back is a subset of the choice of law rules and it's potentially to be applied whenever a foreign court is decided to consider the law of another state. Application of renvoi because the Greek doctrine is considered difficult and its results are sometimes unpredictable. Its application has generally been limited to the first one is the validity of wealth and estate succession, and the second retrospective legitimation by the marriage of the natural parents. Choice of law. Choice of law is a procedural stage in the litigation of a case involving the conflict of law when it's necessary to reconcile the difference between the laws of different legal jurisdictions. The traditional approach looks to territorial feature, the domicile or nationality of the parties where the components comprising its cause of cause action occur. Where any relevant assets, whether movable or immovable, are located, and chooses the law or laws that have the greatest connection to the cause of action. The party themselves may plead the case either to avoid invoking a foreign law or to agree the choice of law, assuming that the judge will not of his or her own motion go behind the pleadings. The court in some states are predisposed to prefer the lex motive wherever possible. Public policy. Public policy or order public is the body of fundamental principles that underpin the operation of legal system in each state. This addresses the social, moral, and economic values that tie a society together, values that vary in different cultures and change over time. Example of public policy. The most fundamental policy and operation of any legal system is that ignorantia juris non excuset. The Latin for ignorance of the law is no excuse. It will completely undermine the enforcement of any law if the person potentially at fault was able to rise as a successful defense that he or she had not been aware of the particular law. The only exception to this rule excuses those of reduced capacity, whether as infants or through mental illness. For example, see the Hague Conference on Private International Law is the preeminent organization in the area of private international law. A state is a set of institutions that possess the authority to make the rules that govern the people in one or more societies, having internal and external sovereignty over a defined territory. The state includes such institutions as the armed force, civil service, or state court and police. The meaning of country, nation, and state. Country is the geographical area. The nation is designed as a people. However, national and international both confusingly refer as well to matters pertaining to what are strictly states, as in national capital, international law. State refers to set of governing institutions with sovereignty over a defined territory. Jurisdiction from the Latin, meaning law, and dicere, meaning to speak, is the practical authority granted to a formally constituted legal body or to a political leader to deal and make pronouncements on legal matters by implication to administer justice within a defined area of responsibility. Procedure conflict. In all lawsuits involving conflict of laws, questions of procedure as opposite to substance are always determined by the lex fori, the law of the state in which the case is being litigated. Forum non-convenience. Forum non-convenience is a legal doctrine used by common law courts to determine issues of jurisdiction, particularly with regard to foreign judgment and foreign court proceedings. The underlying principles, such as basing respect given to foreign court on reciprocal respect or comity, also apply in civil law system, or least alibi pendant. Concern often raised in application of the doctrine is forum shopping, or picking a court merely to gain an advantage in proceeding. Lex causa. Causa for the law is the law or laws chosen by the foreign court from among the relevant legal system to arrive at its judgment of an international or interjurisdictional case. The term refers to the usage of particular local laws as the basis or causa for the ruling, which would itself become part of reference legal canon. The Latin term "lex fori" literally means the law of the forum, and it's distinguished from the lex causa, which is the law the forum actually applies to resolve the particular case. The approach of lex fori, when a lawsuit is instituted and the court has accepted that it has jurisdiction, the parties will normally expect the laws apply, reflecting a presumption of territoriality that each state is sovereign within its own border and the laws of no other state or international body will apply extraterritorially or supranaturally. If foreign law did apply, the state will be less than sovereign within its own borders. However, as social mobility has increased and the internet encouraged people to trade across national boundaries, a need to recognize the relevance and importance of foreign law to dispute resolution has arisen. Forum shopping is the informal name given to the practice adopted by some plaintiffs to get their legal case heard in the court, though most likely to private a favorable judgment, or by some defendants who seek to have the case moved to a different court. Effort to dissuade forum shopping. Court may object to forum shopping for several reasons. Philosophically, the fair resolution of a case should not hinge on technical difference from one jurisdiction to the next. On a more practical level, many judges feel that their courts are overburdened and fear that having the reputation of a forum favorable to certain types of plaintiff will lead to an increase in their workload, thus delaying the dispensation of justice in other cases. Least alibi pendens. The principle of least alibi pendens clearly applies both in municipal, public international law, and private international law to address the problem of potentially contradictory judgment. If two courts were to hear the same dispute, it is impossible that they might reach inconsistent decisions. The, rule, the rules of least alibi pendens. The first rule, res judicata, provides that once a case has been determined, it produces a judgment either inter partes or in rem, depending on the subject matter of dispute. Although there can be an appeal on the merits, neither party can recommence proceedings on the same set of facts in another court. If this rule were not in place, litigation might never come to an end. The second rule, proceeding on the same facts cannot be recommenced in a second court if the least action is already pending in another court. And connecting factors, we have domicile, lex domicile, nationality, lex patria, lex loci arbitri, lex situs, lex loci contractus, lex loci delicti commissi, lex loci solutionis proper law, lex loci celebrationis, choice of law clause from cited clause, and the domicile is the basis of the choice of law rule operating in the characterization framework to define a person's status, capacity, and rights. The international term for this as a connecting factor is the lex domicili, the law of the domicile. Domicile should also be clearly distinguished from nationality, which is the relationship between an individual and a country, where the state and the country are coextensive. The two will be the same. Domicile of origin. A person acquires a domicile of origin at birth. The domicile of a minor child is that of the father if legitimate, the mother of illegitimate, the individual who has primary parental responsibility rights if not a parent, or the country in which he or she is found is a foundling. Under the law of the United States, where a person's place of birth is unknown, his or her domicile of origin is the place to which a person can earliest be traced. Domicile of choice. Once a person reaches the age of majority, he or she is free to choose a new domicile. This choice is effective when an individual has both the factum and equivocally abandons his or her old domicile, and the animus semper menendi enters a new state with the intent to make it his or her permanent home. The lex domicile is the Latin term for law of the domicile in the conflict of laws. Conflict is the branch of public law regulating all lawsuits involving a foreign law element where a difference in result will occur depending on which law are applied. Habitual residence is the standard civil law connecting factor used to select the lex causae in cases characterized as status, capacity, and law family. It matches the common law connecting factor of lex domicile. Nationality is a relationship between a person and their state of origin, culture, association, affiliation, and or loyalty. Nationality offers the state jurisdiction over the person and offers the person the protection of the state. Generally, nationality is established at birth by a child's place of birth and or bloodline. Nationality may also be acquired later in life through naturalization. Corporations and other legal persons also have a nationality. Generally, in the state under whose law the legal person was formed. Some countries do not permit dual nationality, while others only allow a very limited form of a dual citizenship. The term lex patriae is Latin for the law of nationality in the conflict of law, which is the system of public law applied to any lawsuit where there is a choice to be made between several possibly relevant laws and a different result will be achieved depending on which law is selected. The lex patri is a civil law choice of law rule. In some states, the law of habitual residence is used to test the status and capacity of the party to the case. Lex loci arbitri. The lex loci arbitri is the Latin term for law of the place where arbitration is to take place in the conflict of law. Conflict is the branch of public law regulating a lawsuit involving a foreign law element where a difference in result will occur depending on which laws are applied. The lex loci arbitri is an element in the choice of law rules applied to cases testing the validity of a contract. As an aspect to the public policy of freedom of contract, the parties to an agreement and free to include a forum selection clause and or a choice of law clause and unless there is a lack of bona fides. These clauses will be considered valid. If there is no express selection of a proper law, the court will usually take the nomination of a forum as a connecting factor, a fact that links a case to a specific geographical location. Lexitus. The term of lexitus refers to the law of the place in which property is situated for the purposes of the conflict of laws. For example, property may subject to the tax pursuant to the law of the place of the property or by virtue of the domicile of its owner. The lexitus is a choice of law rule applied to identify the lex causae for cases involving title to or the possession and use of property. In law, there are two types of property. Real property is land or any permanent feature or structure above or below the surface. Ownership of land is an aspect of the system of real property or reality in common law systems. Immovables in civil law system and the conflict of law. All other property is considered personal property or personality in common law system. And this property is either tangible or intangible. It's their physical property that it can be touched like a computer, or it is an enforceable right like a patent or other form of intellectual property. The lex contractus is the Latin term for law of the place where the contract is made in the conflict of laws. Conflict is the branch of public law regulating all lawsuits involving a foreign law element, where a difference in the result will occur depending on which laws are applied. Lex loci delicti commissi is a Latin term for law of the place where the tort was committed in the conflict of laws. Conflict is the branch of public law regulating all lawsuit involving a foreign law element where a difference in result will occur depending on which law are applied. The lex loci solutionis is the term for law of the place where the relevant performance occurs in the conflict of laws. Conflict is the branch of public regulating a lawsuit involving a foreign law element where a difference in result will occur depending on which law are applied. Lex loci celebrationis, the law is the term for law of the place where the marriage are celebrated. In the conflict of law is the branch of public law regulating all lawsuits involving a foreign law element where a difference in the result will occur depending on which law are applied. Choice of law clause or proper law clause in a contract is one in which the parties specify which law will be applied to resolve any disputes arising under the contract. Forum selection clause. A forum selection clause in a contract with a conflict of laws element allows the parties to agree that any litigation resulting from that contract will be initiated in a specific forum. Enforcement of foreign judgment. Issues relevant to the enforcement of foreign judgment are frequently regulated by bilateral treaty or multilateral international convention to facilitate the reciprocal recognition and the enforcement of judgment between states. This area of judicial process is growing in importance.
Lis alibi pendens is a Latin term that means an action on the same cause of action is pending elsewhere. When two courts are hearing the same dispute, they can reach inconsistent decision. Res judicata provides that once a case is determined as final, only appeal can rise from the case. No party to the case can commence another case on the same dispute in another court. When a case is pending, no other case on the same issue can be commenced in another court. Lis alibi pendens arises from international committee and it permits a court to refuse to exercise jurisdiction when there is a parallel litigation pending in another jurisdiction. However, when a case is filed about materially different issues, documents, and parties, this alibi pendant cannot apply to determine the proceedings.